Hello, my name is Keith Vanover. I'm a DUI lawyer. I have a lot of experience in DUI law. I have personally handled more than 2,000 DUI cases throughout Northwest Florida. If you find yourself charged with a DUI anywhere from Tallahassee to Pensacola, then call my office right away. We can help you save your driver's license, but you only have 10 days from the date of your arrest in order to get this done. If you miss the 10 days, you can lose your driver's license. Call my office today. What are the possible penalties for a DUI? Under Florida law, these penalties are very extensive, and they go up depending on if you're a first offender, second offender, whether it's a misdemeanor or it's a felony. But you are going to be looking at a list of issues that have a very broad opening that the judge can interpret. And this is what makes DUIs different than most other laws, in that there is a wide range of punishment that they can go through. And that's what makes it so dangerous. So you're going to be looking at a fine, a court cost, probation, a victim impact panel, community service hours, driver's license suspension, interlock device, DUI school, random drug and alcohol testing. The list goes on. And all of these have wide ranges to them, and that's what makes it different. And what I mean by ranges is, let me give you an example on community service. The minimum community service for a first offense DUI is 50 hours of community service. Well, they can obviously go for more than that. And so that is just one example of all of that list I went over, where they have a range of minimums to maximums where they can really screw you over and you don't even know what's happening. So that is why we always say it is important to make an informed decision. And we would like to help you with that information. So all you have to do is call my office, and call as fast as possible, because that 10-day window is closing on your right to drive. And we can walk you through all the aspects of your case once we figure out the exact details of your case, and we can let you know specifically what you're dealing with. And of course, it is a free consultation. We can set up in-person consultation, or we can even do it over the phone if that's more convenient for you. We want to get down to the DMV as soon as possible to keep you driving. So if you're hearing this right now, please give me a call today, and we will walk you through this law and get you through this legal minefield so that you have the best results possible. Are those penalties for each time you get a DUI, or just the first time? Those are the minimum for the first time DUI. When you get charged with a second, a third, or a fourth DUI, it goes up from there. It can start at the misdemeanor level and can then go to the felony level. A third offense DUI under Florida law is a felony if one of the priors is within 10 years, and that includes from any state. It does not have to be all the DUIs do not have to be from Florida. A big mistake a lot of people make is they assume that if they get a DUI in another state like Alabama, that will not be used against you. That is not true. Even though Alabama will drop the DUI against you every 7 years and consider it a first offense, Florida can go back and use those prior Alabama DUIs in order to enhance your current DUI. Usually, the prosecutor will seek what is called an NCIC check, the National Crime Information Computer Database check of your record, and find out if you have ever been charged with a DUI. And believe it or not, the state of Florida can go back into the 1970s and find those DUIs to use against you to enhance your current DUI. You cannot outrun your priors in the state of Florida. It goes back a very long way, and they're very aggressive about enhancing the DUI you are currently facing. Call my office today, and we can walk you through this process with a free consultation.